With this talk, I begin the series of 6 talks on the Union Legislature, which will include discussion on Constitution of Parliament, composition of the Rajya Sabha, composition of the Lok Sabha, duration of houses of Parliament, qualification for membership of Parliament, session of Parliament, including prorogation and dissolution, the chairman and deputy chairman of the Council of Estates, including their powers and duties, the Speaker and the Deputy Speaker of the House of the People, including their powers and duties, conduct of business in the Parliament, powers, privileges, and immunities of Parliament and its members, legislative procedure including a special procedure in respect of money bills, etc. Understanding of the topics covered in these 6 talks would be important for the understanding of 5 books prescribed in your syllabus, namely Rules of Procedure and Conduct of Business in Lok Sabha, Rules of Procedure and Conduct of Business in Rajya Sabha, Manual of Parliamentary Procedure in Government of India, Delegation of Financial Powers Rules 1978, and General Financial Rules 2017. However, in my first talk, I will discuss about the broad and general characteristics of the Parliament, including obligations of the membership. Without the President, Parliament in India is just the legislature. The functions are primarily two: legislative, that is passing of laws, including the financial sanctions, and making of policy decisions through debates and discussions. The legislature is bicameral, comprising the Council of Estates, also known as the Rajya Sabha, and the House of the People, also known as the Lok Sabha. Although parliamentary practice in India has a great deal in common with the British Parliament, bicameralism of the Union Legislature of India has nothing to do with that. Rather, it is based primarily on the federal practice, starting with the USA, of having 2 chambers, one representing the federated states and the other representing the people of the nation. But there are certain differences in the composition of the Council of States in India with the US Senate. The maximum membership of the Council of States is 250, of which not more than 12 is nominating. Such members are picked up from people having a special knowledge or practical experience in the fields of literature, science, art, and social service by the government. Not more than 238 members, on the other hand, may be elected representatives of elected members of the state's legislative assemblies by means of proportional representation. Unlike in the USA, where representation of states to the Senate is uniform, in India the strength of the state's representative varies from state to state on the basis of the strength of population. Such numbers are fixed in the fourth schedule to the Constitution. Now it varies between 31 in Uttar Pradesh, the state with the largest population, and one each in the small states of Goa, Nagaland, Manipur, Tripura, Meghalaya, Sikkim, Mizoram, Arunachal Pradesh, and Puducherry. The strength of each state's representation may vary with the reorganization of states. At present, only 2 of the 8 union territories have representation in the Council of States. The National Capital Territory of Delhi has 3 and Puducherry has 1, because they alone have legislative assemblies. The House of the People is to consist of not more than 550 popularly elected members, of which not more than 530 will be elected from the states and not more than 20 from all the union territories. At present, there are 530 members elected from the states and 13 members from the union territories. The number of seats allotted to the states varies according to the strength of their population, as far as possible, in even ratio. This number will be split into territorial constituencies, as far as possible, in even proportion of population ascertained by the previous census. This is done through the appointment of a delimitation commission. By the 84th Amendment in 2001, however, the next readjustment of constituencies has been fixed after the census following 2026. The strength of representation of states in the House of the People after the 17th general election varied from 80 in Uttar Pradesh to 1 each in Mizoram, Nagaland, Sikkim, these are states, and Andaman and Nicobar Islands, Chandigarh, Dadra and Nagar Haveli, Daman and Diu, and Lakshadweep. These are union territories. Seats are reserved in the House of the People for the scheduled castes, the scheduled tribes, except the autonomous districts of Assam, and separately for the scheduled tribes in the autonomous districts of Assam in proportion of the numerical strength of the communities. Refer to Article 330. There may be not more than two Anglo-Indian members nominated by the President if, in her/his view, the community is not adequately represented in the House. The provisions for reservation and nomination are temporary. They were initially made applicable for 10 years, but were successively extended through amendments. Now about the membership obligations. In order to seek election to be member of parliament, one has to be a citizen of India, to be 25 years of age in case of the House of the People, and 30 in case of the Council of Estates, and possess such qualifications as may be prescribed by any law of parliament. No one can be member of both the houses of parliament. No one can be member simultaneously of a house of parliament and a state legislature. This restraint, however, applies only after a member takes the oath. In 1999, Girdhar Gomango, a member of the House of the People, became Chief Minister of Odisha. He voted in the House on a confidence motion on the plea that he had not yet become a member of the state legislature of Odisha. The speaker noted that earlier members, on being appointed ministers in states, had attended the House but did not vote. He left the matter to the good sense of the member who did vote. A candidate for election to parliament will have to make or subscribe an oath or affirmation to the election commission or a person on its behalf in the following language. I, AB, having been nominated as a candidate to fill a seat in the Council of Estates or the House of the People, do swear in the name of God, solemnly affirm that I will bear true faith and allegiance to the Constitution of India as by law established, and that I will uphold the sovereignty and integrity of India. After being elected, the person has to take an extended oath that commits her/him to faithfully discharge her/his duty upon which she/he is about to enter. A member of any house becomes subject to disqualification for being chosen as and being member of a house on ground of holding an office of profit, or being of unsound mind, or being an undischarged insolvent, being not a citizen of India, or having voluntarily acquired citizenship of a foreign country, or disqualified by or under any law made by Parliament, or violation of the 10th schedule banning defection. Refer to Article 102. Such questions will be referred to the President, and the President's decision will be final. Before giving her/his decision, President shall obtain the opinion of the Election Commission and shall act according to such opinion. Refer to Article 104. However, according to the 10th schedule, The presiding officer of a house is the final authority on disqualification of a member on the ground of defection. If a person sits or votes as a member of either house before taking oath or affirmation or being aware of her oblique his disqualification, she oblique he will be fined rupees 500 per day. Besides these disqualifications, membership of parliament or a state legislature may cease also in the following eventualities: death, resignation, continuous absence for more than 60 days without permission of the House, the days of prorogation or adjournment for more than 4 consecutive days excepted, election to a House of Parliament while being member of another House or of a state legislature. In the wake of the Nirman movement in 1974 in Gujarat, forcing the legislatures to resign, the 33rd Amendment of the Constitution that year provided that if from information received or otherwise, and after making such inquiry as she or he thinks fit, the chairman or the speaker of the concerned house is satisfied that such resignation is not voluntary or genuine, she or he shall not accept it. Refer to Articles 101 and 190. This is in brief about the broad and general aspects of the Parliament, including the membership obligations. In my next talk, I will discuss about the working of the two houses. Thanks for patient listening.